For judgment, item number 1.
Is allowed.
पूर्ण list.
Item 2. Item 3. Item 4. Item 5.
Hello.
Item 6.
Partly.
Item 7.
Indirectly. Indirectly.
Item 8.
Partly. You are partly allowed. Yes.
Item 9.
Partly allowed.
Item 10.
Partly. Yes.
Any mention?
Item 1. What is this?
Item 2.
Item 1 you were
Item 1 है bail तक में solve किया हमने.
already over?
Item 1 solve दीजिए. Weekly list पर.
Hmm.
Item 2 पे आना कुछ नहीं.
Yes. You are.
Item 2.
This is a conviction under section 498, 304, 306 and 4 DP Act. The substantive sentence is 4 years of RI.
Yes.
Since it was involved 4 years of RI, on the last opinion, Lordship has appointed amicus.
Passes. Then nobody is there.
Yes.
Let him pass us. You are in which side?
My lord. I want to make a mention, your lord.
Yes.
Lord, one matter, we have given the several memos. 2474 million, CLMC. Tide of matter, it has been ordered by the Honorable CJ to list before your lordship. Again,
CRLMC.
my lord,
What is that?
2474 by 25.
What is that?
29 years, FR question, final form submitted.
Why
listed
it
as
is
fact.
marked to me?
সেটা হজুর ଆପଣ ଅର୍ଡର କରିଥିଲେ 3 ମାସ ଟାଇମ ଦେଇଥିଲେ ବର୍ଷେ ପଳେଇଲେଣି.
List it. List it.
That is in the list unless your lordship
Tuesday.
obliged.
Tuesday. List it. Give the memo.
memos ହଜୁର ଦେଇଥିଲେ ଆଉ ଗୋଟେ ଦେଇଥିଲେ.
Give the memo in the court so that it will be easier.
ଅଛି ହଜୁର
Whole day
I
in
will give.
in the entire day, anytime you can send your
Yes,
junior.
obliged. I
So
will
that yes. Password करो. There is no one who can display चलती तो
11 का देखिए छोटा
11
11 तक
तो छोटा.
Court to be passwords.
ना
ठीक.
11 तक
Which one is the which we can finish it up?
Item 2 and 4 was password on the other day.
11
11 as
11 let us see. He says is small matter. There were 3 appellants who has died.
5 years.
One has died, huh?
Yes. 304 part 2.
One is died and the other three are there.
The sentence of 5 years, Your Worship. And that's me.
Quite small matter.
Hmm.
Who do? Huh?
5 years attached.
5 is not small. 302 and everything was there. They were acquitted or something of that
Yes.
happened. And they were convicted under section
304 part 2, 149, 323.
304 part 2 and all.
First of all, the 5 years. Take
It will take its own time. Serial.
the period undergone is 12 months. So it might.
Huh?
Period undergone is 12 months. 12 months, 21 days. So it can be done in. But it's not a small matter.
It's not a small matter.
Appellant needed.
Period undergone also you have to appeal the conviction. For that, it's
Yeah.
something you have to write.
Yes.
Item 2. Item 3, yeah?
Item 3 solve.
Sarji,
3. Feature है.
Sarji ji?
Item 4.
Item 4.
4 is under section 304B IPC and 4
This
DCA.
is
This is
Mr.
arrived for 7 years.
Shyamananda
Yes, Your Worship.
Mahapatra Senior will appear. Because this was argued earlier, that's what he was saying.
Yes.
Which Munda came.
Sorry.
Yes, it's all right. Take your breath. Item 2. Yes.
Here is a case similar. The appellant being convicted.
Are you keeping water there or not? You must keep water. Somebody
Can I-
coming running and
CD chari pade.
bottle water and sit
For commission of offense Miller 306 4 years, 498 Miller 4 months and 4 of the DPS.
Yes.
But as the threshold Miller, as I find, the she committed suicide while she was at her parents' home. And more so on a bare perimeter of the PW, perimeter of the PW4, as well as the PW3. PW4 is the father of the deceased and PW3 is the informant. 3 is the father of the deceased, 4 is the informant. On hit Miller evidence, it appears that it may have case of cruelty. 498 established the present appellant and 306 could not be established.
There is no abatement.
No abatement because the offense under section 498A and 306 of IPC are two different offenses. Though Miller 4, that does not mean cruelty attributed to the under section 498A. Suppose a person can be convicted Miller on the ground conviction of cruelty. That does not mean the Miller the abatement and most of the instigation.
You may bring the what you call the presumption clause and 113B and 104B is all right, but 306 for that abatement
Abatement
is
is not
required.
necessary and no intention because this is by staying at her parents' house.
Right.
That committed suicide at her parents' house.
Show me that. Show me that. Let us see. Let us come to
Evidence of
Hmm.
the
the
PW3.
let us PW3 is the main father in PW3 is the father and informant.
PW4 is the
Father and informant, huh?
Yes.
Ah.
No. PW3 is the father of the deceased.
Hmm?
Father of the deceased. And PW4 is the Miller, brother of the deceased who happens to be informant of this case.
The PW4 is the brother, huh?
Yes,
PW4 brother and
PW
informant.
3 is the father.
Let us read their
Evidence of the PW3 Miller.
Hmm.
The
accused
accused
is my son.
son-in-law, he married daughter of the Soba in the Etiki. The marriage between the Solemanite in Toda
Solakoni.
from in the month of Asara during their marriage, I had promised to give
a gold chain for my son-in-law, and few wooden furnitures as marriage. I could not give those materials due to poverty. Shobha reported, I am supplying the detail. Shobha reported me on many occasions to have been beaten by the accused, as I could not supply the gold chain and furniture to them. Shobha has also reported me to have been throughout neglected by her husband, and she was not even being supplied with the food and clothing. My lord.
But the first word is, I had promised. Where is the demand?
My lord, so demand kotha to nahi. That's why the trial court acquitted from the charge of 304 bhi nahi. Demand of down nahi. My lord. Shobha in the year of after Pona
Shobha
Sankar,
died 9 days after the Pona Sankar.
Pona Sankar
1980.
2 and a half before her death, Shobha for the last time visited my house. She stayed with me for 8 days and then left for her father-in-law's place for days after Pona Sankranti Etiki. I had been to the house of my daughter at village Bonapato. During my visit, Shobha
Reminded me.
reminded me to give the gold chain and furniture early and alleged repeated assault on her by her husband for those materials. My lord.
Mm.
In the earliest part of the morning, 23/4/1989, my wife and daughter-in-law had been to the Bari side at my Bari side, and my daughter-in-law detected the body of Shobha to be hanging on the branch of a mango tree. That appears that, my lord, the
In
wife,
their
yes, the submission was that deceased committed suicide at her parents'
my wife and my
Daughter.
daughter-in-law had been to the Bari side, and my daughter-in-law detected that the body of Shobha is hanging so
She came
and reported to all of us.
we went there and saw the body of Shobha hanging to the tree in our body.
Mm.
My nephew Ramakanta Swai caught the rope and brought the dead body of Shobha from tree and made her to lie on the
Bari.
body. As it apparently, my lord, evidence of the decease of the father, my lord, the deceased committed suicide while she was at her parents' house. Admittedly, there is, my lord, cruelty established on the part of the present petitioner on account of non-fulfillment of the demand of dowry. But nowhere it appears that the instigation, abatement by the present appellant to let the deceased commit suicide by hanging itself. Nowhere it appears that, my lord. Then, my lord,
In the cross
after
border
examination, I had gone to my daughter's house on many occasions. After her marriage, the accused came to my house during the marriage of my son Souri. During my last visit to my daughter's house, which is about 4 days after Pona Sankranti last, I stayed there for a day. The accused and his brother and mother live in joint family. The household works of the work are being done by all the female clerks of their house together. During my stay in the house, my daughter, I had talked with her mother-in-law, sister-in-law, and other family members. Whenever I visited my daughter's place, I had talked with all the inmates of the house. That appearance are a good and amicable relation. Members were the family members were sending Bharo and Bhadras.
Vyavhara.
Vyavhara to us, and we are also sending the same to their house. Good cordial relationship between
It
two
was
the
there.
families.
Para both would be relevant.
No, we both the families we are treating each other visitors with good amount of dignity, respect, and hospitality. Shobha had a read class to Etiki. She knows how to write letters. There are many friends Shobha in our village. I cannot say if my daughter Shobha was writing letters to my daughter-in-law. Quote question. The house of my daughter is at a distance of 3 kilometers away from the village. But I have not requested of my villagers to redress the grievance of my daughter. My daughter has not said any information through outsider to me, intimating about the torture made by her husband towards her since after marriage and before death. Shobha visited my house thrice, and every occasion I had gone to her house and brought her to my house with me. The accused never talked with me, Milord, informant. In the contrary, he misbehaved in a manner by standing, showing his behind to me while I would be talking to him. My son-in-law very sensitive. My daughter had alleged about the torture in an indefinite and general manner.
General manner.
General manner. And against her husband. Manner against. I be the most relevant, Milord. I have not been examined by the police. And most, I have not been examined by the police. And more so, I think apparently in her evidence, in his evidence, it made out a case of cruelty. 498.
Let us see fourth case.
That is a similar manner. For is the Milord,
Brother,
brother
an
of the
informant.
deceased who happens to be informant. I know the accused. This is Shobha so and so I think married. Accused in the 1908. After her marriage, Shobha had come to me our house many occasions. Before Asada 1986, there was negotiation. for marriage of
Accused and his brother Ramesh Swai demanded dowry of hard cash of 3,000
I had
and some gold ornament.
I had the house of the accused with Kapila Patra,
Hmm.
who will be the mediator, to finally talk and settle the date of marriage. The accused and his brother Ramesh Chandra Swai demanded dowry of hard cash rupees 3,000 and some gold ornaments for the accused and my sister. They had also put forth their demand that we provided wooden furniture to them. On that very day, I paid rupees 3,000 in cash to Ramesh Chandra Swai, the elder brother of the present appellant. Elder brother, while sending my sister for solemnized marriage in the form of Toda Kanya. We had given all her gold and silver ornaments along with incense etc. The only items that were left to be paid later were the gold chain for the accused and wooden furniture. We could not give the above materials to the accused during the life of my sister Shobha. My sister Shobha had visited our house for about 10 to 15 occasions after her marriage and before her death. On every occasion, she had requested me in a weeping state to give the gold chain to the accused and the wooden furniture. She was complaining all the while that she was being beaten severely by the accused for non-supply of the above demand attitude, but no specific Milord.
Yes.
Before then Milord, on 23/4/1989, I was at Bhubaneswar. It was shown on that day at 11 a.m. I was reported by Sibo Swai, one cousin, regarding the death of my sister Shobha. He also reported me that the dead body of Shobha had been hung up one of the branches of mango tree
In our
situated in our
one.
in our body. On getting this information, I lost my village.
Who is the doctor? Who is the doctor?
Dr. Milord, ଆପଣ କହିଲେ ସେ ଯୋଉ କପିଳ ପାତ୍ର ସାଙ୍ଗରେ ଯାଇ ଡିମାଣ୍ଡ କଲି 3,000 ଟଙ୍କା ତା ଭାଇ ସିଏ ହେଲେ 5 she
Panch.
declared her.
Kopila Panch. Okay, Kopil is Panch.
ସେଇଟା ମିଲ declared as
Mediator. Kopil is mediator.
mediator.
Brother-in-law.
Second cousin brother-in-law, and he along with the informant went to the house of the present appellant, and they were the elder brother of elder
And that 3,000 was paid in front of
paid
him.
him, but
That's
she aga mona କରିଛି ସେ hostile ହେଇଯାଇଛନ୍ତି. At this stage, the prosecution files a petition to declare him the witnesses hostile.
that 3,000 thing is doubted now. Huh?
Then Miller doctor. Doctor is the sixth Miller. The cause of death Miller asphyxia due to hanging.
Any, oh, that's right. But any external injury, anything is not.
Fatal attributed to the side of the informant. But my case, Miller, on a bare scrutiny of the entire evidence of the prosecution, it appears that the ingredients of the offense under section Miller 306 could not established by prosecution yet. Though Miller admittedly case of cruelty on the part of the present appellant.
498 is made out according to you.
ସେ ମୁଁ ସେଇଆ ତ ହଜୁର କହୁଛି
498 is made out.
ସେଇଆ ହଜୁର
What is the sentence given?
490 ରେ 4 months ଅଛି.
And
306 ରେ Miller 4 years. ଏଇଆ ତ ମୁଁ case.
this is a written note you are giving.
May I please? Okay, placing reliance on PW 1, 2, 3, 4, and 6 fixes the document.
Oh, I think.
And even though Miller's cruelty, but that will continue not process. That caused Miller the reason the deceased committed suicide. And because prior to the Miller's commit suicide, prior to the incident, she was at her parents' house.
May I? First of all, the deceased house and the parental house was about 3 kilometers away. And the last total read out on 9 days before the death here. May I place the PW?
Yes.
I know the address. Purnachandra Swami.
Where are you reading?
We don't want.
Yes.
Neighboring witnesses.
Yes, one.
No, so I will show a link, the live link between the death, suicide, and the torture made out by the accused persons, which will be relevant as abatement to suicide at best. I know the accused. Purnachandra Swami is of my village, is the father-in-law of the accused. The accused are married sober.
Who is one?
Neighboring witnesses Miller of the informant. Arapakala. ତାଙ୍କୁ ଜାଣିଛନ୍ତି
Youngest daughter and Purnachandra.
So 1918, the month of Asar, said Sobarani is the youngest daughter of Swans. On 23/4/1989 morning, I learned that the Sobarani is dead inside the body of her father. I rushed to the body in question and found Sobarani lying there with a rope tied to her knee to the other end of which was cut. Another cut piece of the rope was attached to Swans. Sobarani was dead there. 2 months before the death, Sobarani came to my house during her said stay in our village. So it is wrong to say that deceased was staying in her parental house while committing suicide. Since it was 3 kilometers away, she came and committed suicide. That is nice.
Where from we will get it?
Just explain. I am explaining. When I asked her about the marital home, she cried and told me that her parents had not fulfilled the demand of her husband, which were promised to be given at the time at the marriage altar, for which the husband has been torturing her, causing both mental and physical agony. I consoled her. Kapila Patra of my village is the brother-in-law of the accused. Father of the Sobarani is no way.
There is no point. She will come to her house and do it.
So kindly.
If somebody wants to take an extreme step in the life, he'll come to her house and do it. Logically, just think of.
You see,
If there is some abatement, some instigation, then all these things take. If you get a cooling period,
yes,
you never do it.
you see,
It is always a momentary thing.
Is there any cooling period at all? 1986 she got married. Your Worship, as you.
Cooling period is if she is traveling from her house,
Yes.
in-laws house and
Yes.
coming to her house,
Yes, Your Worship.
that itself is a cooling period.
No, I deserve your Worship. And see, Tola Kanya Bhagat. Tola Kanya Bhagat itself shows that agar paisa nahi will say normal marriage.
What is Tola Konya means?
Husband asani wife na pe wife ର ଘର ଲୋକ ଝିଅକୁ ନେଇକି ଛାଡିକି ଆସନ୍ତି ସେଟା ହଉଛି ତୋଳା କନ୍ୟା ଯେତେବେଳେ ଜଣଙ୍କର ଫାଇନାନ୍ସିଆଲି ପୁଅର ଥାନ୍ତି ସେମାନେ ତୋଳା କନ୍ୟା because they can't afford the ବରଯାତ୍ରୀ and the expenses so that is how this ended. 1986 she got married. ସେମାନେ demand କଲେ 3000 and wooden furnitures and gold check. 3000
That is there. That part is there. 498 is made out. I am just wondering before the suicide, what is the immediate and sudden provocation which caused that?
For 9 days and 4 days, that gap I will show you. ପଣା ସଂକ୍ରାନ୍ତିର 9 ଦିନ ପୂର୍ବରୁ ସେ ଘରକୁ ଆସିଥିଲେ ଘରେ ଆସିକି କାନ୍ଦିଲା କହିଲା ଯେ ତମେ ମାନେ ଦଉନ ମୋର ଡାଉରୀ ଆର୍ଟିକଲ୍ସ ସେଥିପାଇଁ ଆଇ ବିନ୍ ଟର୍ଚର 4 days after ତାର ବାପା ଯିଏ ତା ଘରକୁ ତାର ପ୍ୟାରେଣ୍ଟାଲ ହାଉସ କୁ ଯାଇ ତାର ମ୍ୟାଟ୍ରିମୋନିଆଲ ହାଉସ କୁ ଯାଇଥିଲେ again she complained about the torture. Thereafter after 4 days she committed suicide.
Okay.
So that is the live link between the suicide and the abatement by the accused. I'll just place that. So I'm just trying to PW1, I'm trying to impress you that the mental agony was constant.
That is always there. That is
Every
always concern.
saturation point. Every person has a different kind of mental state and a saturation point. And look at the age.
That
of the
can
person.
see these kind of things are there are emotional issues. Yes, she has been tortured. It is a constant mental pressure going on. That's there. But again, therefore, when you are under constant mental pressure, there should be a breaking point where you can go and take the extreme stage.
Absolutely.
What is that breaking point?
Just place that. I'll just place it.
Where is the what do you call that triggering
Yes.
issue?
Soon before the committing of suicide, I'll place the link.
Soon before,
Soon.
that part you just soon before what had happened?
There is no evidence on record that she was staying at her parental house while committing suicide. Her dead body was found at the bari of the parental house, but she was not staying. Before 9 days, she came to the house of parent and she left.
That's not coming clearly.
Yes, Mila.
Though
That is not. I'll just place.
that
I'll
is
just
not where from you
Yes.
get it? Which witness?
PW 2, 3 and 4.
Let us see too. I read it too. Who is two?
Who is this in neighboring witnesses?
In paragraph 2, she says the deceased complained about the torture and the mental agony for want of adequate dowry.
Nowhere the specific evidence available prior to committing suicide. The deceased on that fateful day came to the house of the informant at her parents' house. Even if the said fact might have been clear from the evidence of the PW3 and 4, father and brother. ସେ ତ କହିପାରୁଛନ୍ତି ନା ଆମ ରାତିରେ ତାଙ୍କ ଘର ଥିଲା ଆମ ଘରକୁ ଆସିକି ସୁଇସାଇଡ୍ କରୁଛି କୋଉଠି ଏ କଥା ନାହିଁ।
One more aspect also you can think of a girl who belongs to this kind of family where the poverty is there and all, and marrying and going to another house,
Yes.
having the similar status,
Mm.
level of mental agony will not be like that. She is used to it. She is used to it because the poverty and everything is a part of her life.
Poverty is a part of it, but torture is not. The physical and mental torture is not.
No, I am talking about if there is nothing coming on record, physical torture.
No,
It is only mental torture.
Physical and mental torture is on record.
Therefore, if physical torture would have been there, doctor would have said any.
maybe that's-
See, these people are what do you call? How will I express these kind of people? Those who born in this kind of unprivileged family, they are tuned to every kind of mental pressure. Related to finance, related to all these things. They are tuned. Their bodies, what do you call? They are ready with all kind of situation. They are very tough people. Very tough people. Unless physically torture,
place the physical
Physically torture would have been a trigger point.
Yes, sir. I'll just place the physical torture. PW1.
PW1, yes.
Sorry, PW2.
1,
PW2.
2, yes.
The page 2, Your Lordship.
Is para?
Page 2 of the PW2.
Yes, yes.
During the marriage of Saudi, brother of Shobha came to our village. She came to my house and told me that her father had not given the furniture, gold chain to her husband. The accused had been repeatedly abusing and assaulting her. She also alleged that other members of the marital home were also abusing and subjecting her to the lot of mental agony for adequate. So assaulting part vis-a-vis the accused is there. And he is an independent witness, no way family member of the deceased. Then also I will place the PW3 in indirectly. The accused is my son-in-law. He had married my daughter Soba in the 1986. The marriage between them was solemnized in Tola Kanya form in the month of Asara. During their marriage, I had promised to give gold chain for my son-in-law and few wooden furniture as marriages. I could not, Your Lordship, PW4 statement is constant that there is a demand of love. I could not give those materials due to poverty. Soba reported me on many occasions to have been beaten by the accused as I could not supply the gold chain and the furniture to them.
Yeah.
So assaulting part is again there. Soba has also reported me to have been thoroughly neglected by her husband and she has not been supplied with food and clothing. Soba died 9 days after Pona Sankranti 1989. 2.5 months before her death, Soba for the last time visited my house. This is my contention, Your Lordship. 2.5 months before Asala, Sedina se asin. She stayed with me for 8 days and then left for her father-in-law's place. 4 days after Pona Sankranti of 1989, I had been to the house of my daughter at village Bonaparte. During my last visit, Soba reminded me to give the gold chain and the furniture early and alleged repeated assault on her by her husband for those materials. That is 4 days just before their death, Your Lordship. In the earliest part of the morning, 23/4/1989, my wife and daughter-in-law had been to the Bari side, and my daughter-in-law detected the body of Soba to be hanging on the branch of a mango tree. She came and reported and so on, so, Your Lordship. And thereafter, as you Lordship,
See, this PW2 in the cross examination, again, he says that Soba, he says that Soba described about the torture to have been committed against her in an indefinite and general manner. It is general allegations.
general application. Mr. May kindly see the paragraph 2 for a moment. I'll just repeat the
2 of
exact PW2, Your Lordship.
PW2, yes.
PW2.
No, that I read. Physical torture. Assault.
Accused has been repeatedly abused
And assaulted. Assault. That's it.
Then PW3 had just stated, Your Lordship. 9 days before. May I repeat the PW3 for a moment?
How many accused are there here?
One.
Only husband.
Husband.
And what about the other? Everybody is.
He accused only faced the trial.
Uh-huh.
Only the husband faced the trial.
What would be his age now?
He was 28 in 1991.
He was 28 in 1989. 89 the death has taken place. 90, okay, 90.
1991.
90 means another, how many? 30, 35 years.
More than 3.
Huh?
There's 63 now.
63. Undergone period how much? Take it up.
Period, my lord.
Check it, I'm just coming within seconds. Just check it up undergone period. I'm just 1 minute. 1 minute. Yes. There is a
Arrested the accused Miller on 6/5/1999.
नहीं 6/5 नहीं
हाँ, I arrested and the accused during the course of the day. 6/5 forward करे, 6/5 forward करे.
ये 6/5 रे arrest ले
6/5 forwarded to the accused.
6/5 89 huh? Arrested and bail
ये चालू
TCR just check the TCR. Order sheet just 6/5
6589
bail bond is there. One see 16/5/89 their bail application rejected.
on 18/5 also bail was rejected.
Huh?
On 18/5 order that shows on receipt of bail rejected orders of CRLMC number so and so in respect of the
Find out.
so and so.
One
Bail
minute.
rejected.
Fourth August 89 the bail bond he has furnished.
From jail custody. 4/8/89 he has granted bail.
Huh?
4/8/89.
Huh. The 4th August
89.
yes 89 bail. So then he remained
20
in June,
That's
July,
okay,
August,
15
3 months.
Around 3 months.
3 months, huh?
Two days come.
3 months.
Around 3 months.
And here, after conviction,
3 months.
4 year sentence, na?
Yes.
So 389 benefit might not have been given. So let us see. Here, after judgment was passed on,
there's 24/1/91.
24, 194,
91.
91.
Bail
And he
granted
was
by
granted bail in
30th
30 Eco 91.
30th January. So by the time he was already in custody regarding the judgment.
6 days about.
6 days.
6 days. 3 months, 6 days.
4 days ago.
3 months, 6 days.
In the meanwhile, we didn't appear. MBW was issued, which it still has not.
Huh?
NBW was issued on 1/12/2014. That has not yet been executed.
During pendency of the appeal, my lord. Because no reproduction.
There is a judgment of Justice Vikramna on 306.
Yes.
There he describes what is the
Indeed.
soon before the commission of this suicide.
Soon
What are
before,
the
my lord,
triggering
not necessary.
points?
Soon before, not necessary. Soon before, that is, my lord, in respect of 304.
304,
Immediate
Immediate,
continue.
immediate,
Here continue
Triggering.
my lord offense.
immediate triggering point is
Instigation of the affair, my
necessary.
lord.
Yes.
Is that is the ingredient of 306.
Yes,
my
my
lord.
lord.
Because this is a momentary decision taken by someone. Very momentary decision. If it is
Because
going on and on and on, it
Cruelty,
may not be a cause for
cruelty or torture, my lord, became unbearable. That cause leads the deceased commit suicide. That
for
is-
unbearable. If it is going on,
Yes, ma'am.
unbearable will come when the triggering point is there.
Yes.
What is the last point? Where the beer, she
My
can't bear
yes,
anymore.
my lord, as it appears from the evidence of the
That is why I am saying
Yes.
the witnesses are saying that assault, physical, mental.
that, my lord,
At the
relates to
same
the
time, they are
cruelty.
saying general allegation.
That relates to the cruelty, non-fulfillment of the demand of dowry. That I admit, my lord.
That's
But
right.
that does not mean
Now, what she is
the
trying to
cru-
say is
Court
there
will
was
just-
physical assault, mental assault.
Yes.
Okay.
Just-
But in the same time, the same witnesses are saying these are indefinite and general allegations. are
Yes,
there.
ma'am.
So therefore, what is the point where she could not bear further?
Yes.
Something might have happened in a particular day. Thereafter, he said that no, it is done now. What is that point?
And moreover,
What is that point which is coming on record?
Yes, sir. I'll
What
just
is that
place
point?
PW 3 and 4, I'll just place two.
Again, they are general. I read it.
No, yes,
Why?
yes.
Why
It's
so?
not generalizable. And I'll be placing a judgment of 2022-24 Supreme Court, Your Lordship. Prakash versus State of Maharashtra, author B.R. Gawai. This is B.R.
Just Gawai.
Yes.
Just show me.
There's a live link between
Mine
the
is
suicide and.
Just
Just,
show me that.
The case 450 and
That's,
306.
I'll just
two
place.
different.
Different offense. That's you have done
Once
that.
cruelty made out, that does not mean the
If
automatically.
the cruelty made out, that would be a part of this is the fit case of 304B. Fit case of 304B.
So I'll
But
be-
unfortunately, 304B, they have acquitted and 306 is involved.
Probably sure.
I don't know why 304B should have been.
I can't improvise the facts.
I don't. What is the
As-
reasoning given by the trial court?
Party. I'll be placing the judgment.
Show me that judgment.
Yes.
What is the reasoning by not?
It is live. You should just-
Yes. Let me get that judgment.
It says there should be a link between the last instigation abatement as well as the suicide committed. I'll place that link. PW3 paragraph 2.
Yes.
Shobha died 9 days after Pona Sankranti 1989. 2.5 months before her death, Shobha for the last time visited my house. She stayed with me. It is the evidence of the father.
She
She stayed. Technically copy there. She
That's what it means, sir, with that.
She stayed with me for 8 days, then left for a father-in-law's place. 4 days after Pona Sankranti. I'll just repeat. Shobha died 9 days after Pona Sankranti. 4 days after Pona Sankranti 1999, I had been to the house of the daughter of my daughter at village Bonapat. 4 days before the death. During my visit, Shobha reminded me to give the gold chain and furniture early and alleged repeated assault on her by her husband for those matters. It's just 4 days after, before it. And she was in her matrimonial house. We do not know what happened in those 4 days.
So that do not know pointing biggest problem.
The father of the deceased, she went to her deceased daughter's house just before 4 days before her death. She repeatedly assault for non-fulfillment of the dowry, and 4 days she was there only. The link is established.
Which part of judgment you are saying?
As
Justice Bikramnath's judgment, take it out.
one.
Justice Bikramnath's judgment.
Yeah. Paragraph 28.
20.
Please, paragraph syllabus. I'll place para 11.
Para 26, read it.
Para 26 is the concluding paragraph. That covers almost everything.
Para 26.
And then place
says-
25. 25 on.
This test is very important. The test is the close proximity.
Yes, Lordship. Para 20, that
Close proximity is
Yes.
the test.
Yes,
Para
25 onward.
25. Relying on the decision.
Question of Sanju alias Sanju Swanso. And in the this court of the Gurjit Singh, set aside the conviction of 306 was clear from the evidence on record that there was a time gap of 2 months between the last visit of the deceased to a palace with regard to the illegal demand of dowry by the accused and appellant and the date of commission of suicide by the deceased. There is a time gap of 2 months, Your Lordship. As such, this court held that there was nothing on record to show that there is a proximity nexus. That proximity nexus, I am showing that PW2 is 4 days before the death of the deceased. PW3 went to her house where she complained about the repeated assault and non-fulfillment of dowry, Your Lordship. Then para 26. Thus, this court consistently taken a view that instigation or incitement on the part of the accused person is a gravamen of the offense of abatement of suicide. However, it has been on many occasions that in order to link the act of instigation to act of suicide, the two occurrences must be in a close proximity to each other so as to form a nexus or a chain, with the act of suicide by the deceased being a direct result of the act of instigation by the accused person.
Para 27 reading.
Para 27, yes.
Hmm.
This court in the case of Mohit Singh reiterated that the act of instigation must be of such intensity and is
Such intensity.
Yes, Lordship.
Such intensity
Intensity.
and in such close proximity that it intends to push the deceased to a position
Under which
the person has no choice but to commit this suicide. This is the test.
Yes, Lordship.
This is the test.
As this place again PW3 para 2.
I read it. Evidence I read it.
Yes, Lordship.
The
In that part,
intensity and the close proximity is the triggering point
yes, yes,
for someone to push to the to take an extreme step in life.
yes, sir.
What is the intensity of the incident
Yes, sir.
which has triggered and which runs very close proximity to the incident?
Okay.
That's the test you have to satisfy.
Paragraph 20, I'll just place for a minute. They have quoted the
Let us see the reasoning of the trial.
I'll just place the reasoning they have given. It is also to be borne in mind that in case of alleged abatement of suicide, there must be a proof of direct, indirect act of incitement to commission of suicide. Merely on the allegation of harassment is not.
Which paragraph?
Paragraph 28. Then I'll again place PW3 regarding that proximity and the instigation as the triggering point. May I place para 2? Para 2 or PW3?
That I read. Judgment used to. That I read.
अरे movement मिला.
That I completely evidence I read.
So 4 days before, the father of the deceased goes to her house.
That I understand.
Please.
9 day before the Pada Sankranti, 4 days before he has gone, 5 days gap is there in between. In between.
9 days, we are not concerned about the 9 days anymore. Concerned about the 4 days. Just 4 days before her death, she says that she has been repeatedly assaulted by her husband and for non-fulfillment of the dowry, and she requests her father that.
No, he doesn't say that 4 day I went.
No,
Let us see once again.
Says the Lord.
Let us PW.
PW3, paragraph 2.
Hmm.
Over the page, page 2, your Lordship.
Yes.
Start begin. 2.5 months before her death, Sobha for the last time visited my house. She stayed with me for 8 days and then left for father-in-law's house. 4 days after Pona Sankranti of 89, the house of my daughter at village Bonaparte. During my visit, Sobha reminded me to give the gold chain and furniture early and unless repeated assault on her by her husband for those materials. Thereafter, after 4 days, she committed suicide.
But in the cross examination, again, he says that my son in law is very sensitive.
No, no,
My daughter had alleged about the torture in an indefinite and general manner against her husband.
paragraph from he says that
See, that's dilutes the first in the cross examination. The same witness dilutes everything. He says that in the general way, he says,
not general.
and indefinite. So therefore, see, try to appreciate the even if a judgment which you place the judgment requires two tests, which is intensity and close proximity. Intensity is not in the general and indefinite manner. Intensity is he has tortured me, he has beaten me, black and blue, and all this thing. And the doctor doesn't find anything in the external. What is the physical torture of that intensity which will push this lady to take extreme steps? That is the test. That test is not satisfied.
My submission of the PW 1, 2, 3, and 4 completely state that
498 is made out. I'll enhance the
Yes.
if you
Fine.
say sentence.
For a moment,
6 month, na? I'll impose fine.
yes, madam. For a moment, Miller, my case is without going to any judgment and the Miller, look, for a moment, Miller, for establishing the offense under section 30C. 30C is the Miller punishment for the abasement of suicide. First of all, I have to Miller go through the section 107 of IPC.
Yes.
That is abatement, Miller. I am
Well, again, the definition of
yes,
abatement is
107.
yes, yes.
107.
First test.
Abatement of a
In
thing.
instigation, any
Yes,
person
of
to
course.
do
A
that
person
thing.
abet the
Secondly,
doing a
engage-
thing who first instigates any person to do that thing.
Yes.
मोर से पार्ट रहे इंस्टिगेशन की चिन्ह तू जा मरी जीवु भी सखाई देबु
Yes.
तू मरी जा मो इंस्टिगेशन नहीं
Engages
coach. with
one
সেটা বলছো না না then
one and more.
engage
other
with
person-
one or more other person in any conspiracy of
এটা বিয়ে।
doing of that thing similar nahi if any act or illegal commission take place in pursuant to that conspiracy and in order to doing that the thing. Third, intentional aids by any act or illegal commission the doing of the thing. ମୁଁ ଇଣ୍ଟେନସନାଲ ତ ବାଡେଇ ତୁ ଯା ସୁଇସାଇଡ କରି ତିନିଟା 107 ତ ଆগে ଆସୁନି ଆବେଟମେଣ୍ଟ ତ ଆସୁନି ଆଉ ପନିଶମେଣ୍ଟ ଫର ଆବେଟମେଣ୍ଟ ସୁଇସାଇଡ କୋଉଠି ଆସିବ 306 ଆଜ୍ଞା ଇନଗ୍ରିଡିଏଣ୍ଟସ ଆগে ବିଫୋର going to the 306 the prosecution must have established the 107 and more so the entire case of the prosecution does not fall on the beyond reasonable doubt as because the on the query of the Todakona no demand of doubt the PW4 informant Millard himself before that at the time of negotiation 3000 टंका Millard dele
डिमांड घेतला 3000 टाका दिले होटेल
That is that's Kapil has
then all
Kapil
the
created
cruelty,
doubt.
yes, all the cruelty attributed Millard on account of non-fulfillment of
Sure,
dowry.
I-
That's why Millard 498A could Millard establish in this case. As Millard threshold, I am saying Millard that.
I have not made any notes so that I have to give dictation right now. सुनी क्या sir? Otherwise, what happens is I hear it and I make up my mind when I don't give dictation, then again I have to read everything.
And moreover, if
And I am not making any notes.
Submission supported by because this is Jagdev Singh.
joy,
Give that citation. Citation will take out the
Citation.
She will go. Subhalakshmi will give that citation. What is that?
Jagdev Singh, Kapil Singh.
He is more tech savvy. He'll give you.
Anuj Justice Vikramath and
Yeah, that judgment I have. That judgment only. This is Bikramnath judgment. That is a very,
Yes.
very good judgment. You must read it.
Equivalent and family.
Prasanna?
That judgment is very, very, he has described everything.
Darjeet Singh province.
And in one of my judgment, I relied upon that judgment. So therefore, I have read it.
Yes, sir, sir.
वो judgment को print out कर दिया हाँ? Yes. That judgment is very good. Yes. Okay, thank you, Mr. Ponda.
ମୋର ଗୋଟେ ସେ ୱିକଲି ହିସାବନେ ରହିଲା ବେଲ୍ ପାଇଁ
Report has come.
Yes, sir, also.
दो report दे दो. क्या report आया? 51 ना? What is report? Not involved in any case. कौन इतना?
ଖାଲି ମିଲ ଟିକେ ଏନହାନ୍ସ ହବ ଆଉ ସେଗୁଡା କିଛି ଦରକାର ନାହିଁ
जजमेंट शेयर कर दो जी जज देखिए वो 46 जज जज
Where from I'll get the custody period?
Period from judgment.
Show me the judgment. Imprint judgment.
At the time of 3 years and 29 days.
Huh?
Running period Miller 3 judgment.
Judgment, yes. What is his name? Name is Santosh.
29 days. He had already paid. And here he Miller 3 years.
Raman Chaudhary 55 years.
ସମସ୍ତେ ସମାନ ଦିନ ବଟ୍ ଯେହେତୁ ଆଜିକା ଅର୍ଡର ହବ ଆଉ ଗୋଟେ ଏକ୍ସଟ୍ରା 1689 ଡେଜ୍ ଥିଲା 18/9/2025 କି 1689 ଡେଜ୍ ମିଲ 11 ହେଲେ more than 60 days add ହବ
Tell me which.
paragraph ମିଲର 6 ରେ ମିଲର
1 minute, I'll just let me.
judgment against Miller running period 2. Both the accused at the time of conviction 3 years and 29 days. Internal page 2.
Yes. The present IE 51, the IE entry bill IE was taken up for hearing on 16/10/2025. The following order was passed. Pursuant to the aforementioned order, the IAC Balangir Town PS has placed on record a report dated 6/11/2025 entry stating that insofar as the accused Ramananda Chaudhary,
Yes.
accused Ramananda Chaudhary is concerned, he has no criminal entity. The report is taken on record. On the strength of the aforementioned position, Mr. Hon'Ble Ponda, that is counsel for the appellant, submits that itu para 3 para 3 itu kata je para 3 पूरा ठीक है इसको तो तीनों एरी पूरा ठीक है apart from the aforementioned submission, Mr. Panda further submits that by order dated 18/9/2025, the co-accused Santosh Kumar Singh, who is similarly situated with the petitioner, has already been enlarged on interim bail for a period of
3 months later.
for a period of 3 months. For a period of 3 months. He too is entitled to the same relief. Relief. Regarding yet to the report submitted by the IIC Volunteer PS and submission made by Mr. Panda and the Council for the State, keeping in view the order dated 18/9/2025 passed in criminal appeal IA number 1233 of 2024 in IA number in criminal appeal number 498 of 2024, inclined to grant the present appellant interim bail for a period of 3 months from the date of his release, with the appropriate condition to be imposed by the learned trial court. Immediately after expiry of the interim bail period of 3 months, the appellant surrender before the jail authority. Lease the matter. Now, while enlarging the appellant on interim bail, the appellant shall also furnish local security and also furnish its present and permanent address, besides other conditions to be imposed by the court below as it deemed fit and proper. And verification of the address, the trial court shall release the appellant on interim bail. Lease the matter after 3 months.
May I? Regarding that judgment, you know, can you data para produce the distribution part?
Which one?
Bikram.
Just with the one, yes.
Para 20 onward, they have discussed the ingredients of the 306 and the fulfillment. Let's just place para 20.
They have dealt with 107 also.
Yes,
Sorry.
yes, ma'am. That is
26 step order, 24 and 26 step, 24 coach. Therefore, for a conviction under section 306 IPC, there must be a clear evidence of direct or indirect act of incitement to commit suicide. The cause of suicide, especially in the context of abate, involves complex attributes of human behavior and reactions, requiring the court to rely on the cogent and convincing proof of the accused's role in instigating the act. Mere allegation of harassment are not enough unless the accused's action are so compelling that the victim perceived no alternative but to take their own life.
Therefore, so compelling.
So compelling. I again say to move 4 days before the set up such
But at the same time, you must remember what kind of the girl belongs to which kind of family.
that differs. That is
This is no more.
So I'll just say the
Had it been from a respectable family, gone from a different circumstances and forced to another circumstances,
should the-
then those things would have been more, mental torture. But she belongs to the same class of family.
physical torture part is like my
Physical
submission
torture.
is that
Yes. Which paragraph, madam, you are reading?
24.
Which paragraph you read?
Para 24.
24. Yes, I'm there.
Yes.
I'm there. Yes.
It examines whether the accused conduct, including provoking, urging, or targeting the victim's self-esteem, created an unbearable situation. If the accused's action were intended only to harass the expressed anger, they might not meet the threshold for abatement of instigation. Each case demands a careful evaluation of fact, considering the accused's intent and its impact on the victim. Para 26. What triggered the apex court to discharge the accused? On a careful, close consideration of the fact and material on record, the present case and in the light of the law laid down by this court regarding section 306 IPC, there appears no proximate link between the alleged facts, instances of harassment, and her subsequent death by hanging. The alleged incident of selling of gold ornaments and subsequent physical mental harassment as alleged occurred almost a year before the FIR was registered at the instant of the father of the deceased. Even the statement of deceased cousin only mentioned instances which occurred a year before prior to the death of the deceased. Further, selling of gold ornaments and the same was followed by discord and harassment upon their demand, even if true, do not reflect any intention to instigate inside the proposal. So in this particular case, the link was year before it. In the case at hand, it was a live link within
Page
6 weeks.
para 26.
I was just placing para 26 only.
But it says, just see, mere harassment and such issues between the wife and husband,
Yes, Lordship.
along with the in-laws, do not appear to create a scenario where
She was
left with no option
Yes,
other than to end her life.
Lordship, a case of
You are
fact.
bringing harassment. See, to the extent the Supreme Court has said, if there a quarrel takes place,
Yes, Lordship.
the husband says that, the wife says that I'll go and die. The husband says that go and die. He goes and commits suicide. That is not abatement.
Absolutely, Lordship. In paragraph
And
three,
the husband is drinking. The wife says that don't drink.
that is some.
Then she says go and die. And even to that extent, the court says no. It's not abatement.
Facts are not at par with the paragraph 3 re taro case ta fact ta hichi 2009 re the deceased got married to the accused person. In 21 re the incident hela. तो एथरे से जो डिमांड ऑफ डाउरी रे किछ नथला से गोल्ड रखला से बिकी देला बोली से कहला बोली वर्षे पूर्व से इंसिडेंट आइतला देन कमिटेड सुसाइड सेति पे कि यार फादर इन लॉ
No, the ratio isn't you see. Forget about the point. Ratio isn't is
received said that the
mere harassment, physical or mental, unless there is a incident which is a triggering point, which must be
Yes.
close proximity to
I
the
again just resubmit that.
four. Again, you are saying 4 days.
4 days before the day she was
4 days is all right. 4 days. What is the
intensity.
what is the incident?
Incident.
4 day has to there should be an incident.
That continues.
That is what the ratio is. He says that the continuous harassment is no instigation.
Continuous harassment. They said it started from 2000.
Continuous harassment with a triggering point where it is beyond his capacity to tolerate further. He commits suicide. That is the test.
These are human minds. So we do not know where.
That's the problem.
We share.
See, the problem is that there is harassment. Continuous harassment is there. No doubt about it. But where is the triggering point? 4 days, okay. 4 days is also proximity. Okay, proximity theory is satisfied. But what is the triggering point? What is the incident 4 days before? You show me what is the incident.
My submission.
Incident is general, undefined harassment. That's what the evidence is. See, that 4 days also say in the cross examination is that general allegations. So therefore that instigation, the triggering point instigation is missing here.
My submission. I'm just re-repeating myself. I don't.
Yeah, you are doing your job, and that too beyond question. You're doing your job. But do you have to read the evidence?
Pardon me. I couldn't follow you.
These are very interesting theory. You know, it has to be. The evidence has to be there.
Yes.
That's it would have been a very good case for 304B. Direct case for 304B because presumption could have been employed.
Dead body found in the body of the parental house. She has been. The conviction has been under section.
But this is an unnatural death. And
304B
if you are saying that 3 kilometers away from her house and all these things could have been considered in 304. That's it.
304B on the face of the evidence of the PW 3 and 4, nowhere the father of the deceased stated that demanded. I commit not yes, soon before her death. Demand of dowry most ingredients soon before of the death.
Section 4 is not there.
304B as because soon before her death.
Section 4. Section 4 is not there. That's
There was demand of dowry most required.
but no, PW 4, the brother says there is demand of dowry.
But that not proved by the independent brother.
Kapil has
I am Mukichi 3000 deyni.
brother's statement is doubted by the Kapil statement. Father doesn't say that there is a demand.
That is demand. That's why 304B acquitted.
Kapila is the brother-in-law of the accused.
ଯାହା ବଲେ ସେ mediator ଥିଲେ ନା ତା ସାଙ୍ଗେ
Maybe,
ଯାଇଥିଲା।
but see, father doesn't say that there is a demand.
Demand. I had promised.
I promise to give it.
I promise thereafter the
And if it is a Tula marriage, whatever,
Yes.
Tula marriage, there is no necessity to promise from your side. He promises, sir. Himself.
Necessity to promise is always there in every kind of marriage.
So there is no demand in so far as father is concerned. Torture is there.
Yes.
Torture is there because the promise is not fulfilled.
Not fulfilled.
Yes.
The brother says that there was a demand,
Yes.
and he says that 3,000 rupees I paid in front of Kapil,
To the
who is a
elder-
mediator and a relative also. Kapil says that it was not paid in front.
But Kapil totally become hostile, Yarosh.
Kapil says that-
1, 2, 3, 4.
The 3,000 story goes.
2000.
It's not question of 3,000 or 2,000. It is not the question of whether the demand was made prior to the marriage, during the marriage,
But
or
it-
after the marriage.
But
When-
PW4 testimony, there is a dent created by the prosecution.
So
They have
that-
created that dent.
That's why the case of the prosecution does not fall on the beyond reasonable doubt.
The problem is if these appeals could have been heard in the
Immediately.
right time, then one can think, because every time it runs in the mind, 89 incident happened. This man is 65. These kind of appeals should have been heard immediately.
Immediately.
Then you would have.
It is
How the cost type.
Justice.
Get justice.
See, this is what is happening. Everybody might have forgotten everything by now, and you are unsettling by sending someone to jail at this stage.
Again, huh?
You are unsettling two family.
Absolutely.
This is not the idea for our criminal jurisprudence. Criminal jurisprudence is reformative. Penalty is for reformative purpose. But sending them at this stage is very, very.
Doesn't look justice to be.
So I will increase the fine amount and acute in 306, convict in 498, and maintaining the sentence, I will increase the
Yes, yes.
fine.
One more judgment. Honorable Supreme Court. Whether if we have demand of money from the wife or her parents for running a business without anything more would be constituted.
Applicable.
That's the heading running business.
That demand, but this judgment is direct. Both the judgments are direct.
106 and 107.
Both the judgments are direct. Many judgment you will get on this, like, yes. Yes. Thank you, Mr. Ponna.
Item 6.
You ready with
Yes.
which matter?
6.
Tell me the facts.
Initially, my FIR was lost, to counter my FIR lodged against the informant. One FIR was lodged against the informant in 43.
Mr. Ragada, I'll hear you at 2 o'clock. Be relaxed so that I'll. Yes.
One FIR was lodged against the informant in this case, my lord.
This is the file where something was missing.
Yes, my lord. Yes.
Now you located everything.
Yes.
Okay.
Everything was there, but
Yes. Offense?
307, this petition appellant has been convicted by 307 and 506 34 IPC, ma'am. Initially, FIR was lodged against 3 persons.
It is.
Yes.
Just scan it.
4 persons, my lord.
Yes.
The police submitted false report. It is to be false case. Thereafter, the London court, the HGM court, took Siamo to cognizance against 3 persons. One Gokul Biswai, Ganpati Naik, and Praful Naik. During trial of that case, the additional PP filed a 319 petition. By virtue of that, I have been summoned and admittal issued. I faced trial, convicted man.
What about the other people?
Other people, madam, last time I submitted.
They died. The 107.
No. That appellant has convicted and filed an appeal matter. That appeal was disposed of by in 2007.
Disposed of by what order?
That is not there, but it is in the Loko Adalat.
How can the 307 Lok Adalat?
Yes.
No, he might be convicted just for some other offense.
Convict.
Order me. Our file କଣ record?
Records are archive machine destroy soft copy
Digital archive ଥିଲେ ବି digitalize ହେଇଥିବ।
soft copy print କରି
बाकी କାଣ ନା ଭାଇ, see, if I pass some order, already there is an order pertaining to the same incident,
Yes.
and you are in a lower pedestrian because 319 in your case.
And I have been sufficiently.
They were actually in the other two cases, actually cognizance is taken by the direct
Yes.
magistrate directly. You closure report was filed, it's all right. He is in a different pedestrian altogether. If those people are acquitted, and under the aid of 319, if you can't send him to
Yes,
jail.
Absolutely.
And I have been sufficiently punished, madam, in custody since for 2
No,
months.
one
2 years
more
and
credit is
20
that,
days.
So I'll dispose them.
and
Bring
one
it.
more credit is against the present appellant, your lordship, and the date of pronouncement of the judgment, the present appellant accused was absconded. That
No,
is
no.
the one more credit against
No,
the present
no.
petition also.
That is not submission.
Yes, I'm
ठीक है. That is neither here. Now he is a
Yes,
convict.
it's split off.
Now he is a
No,
convict.
I'm not saying, your lordship, the other accused person was discharged, acquitted, then why the present
Split up when?
split off when that, lordship?
Oh, he was summoned in 319. Where is the question of split up?
On 31st of March 89, Lord Judge took cognizance against 3 accused persons. Madam.
In that trial, you have been summoned.
Yes.
Then where is the question of splitting up?
It was a judgment, your lordship, there is clearly mentioned.
Hmm?
In judgment is clearly mentioned.
Where does it say?
The incidents took place in a house. Whether 2 persons supported and 1 in a supporting one. Whole allegation against one Ganpati Naik.
Ganpati Pike.
Yes. And my role is that I was present there along with that Ganpati.
That Ganpati appeal was disposed of.
That is not Gokul Biswa has filed appeal, madam.
What happened to Ganpati?
No instruction.
Yes, what happened to Ganpati?
That particular lordship,
Because
another appeal was, but
Ganpati देखी रहा है Ganpati.
सेटा मिलुआ नहीं, not in uploaded in the.
last time submitted in this honorable that Lorna Session Judge that original document to be submitted to Honorable High Court in 251 of 90 matter.
Hmm.
That was in respect of Gokul Biswai.
But what happened to Ganpati? Ganpati which file is it? Check kari then. Huh? Because see, all allegations are against Ganpati, and he was only present there. So therefore, 319 was invoked. If he is acquitted, even if you are present, how does it make difference? If his appeal is pending, then it will be again prejudicial kind of situation. Very dangerous. Gokul, what happened to Gokul's order also?
Gokul Biswai, that appellant in 251 of 90, that order was passed to be disposable in local government. So, in respect of other 2 accused persons, that
Gokul judgment is not there with you.
Gokul has filed appeal matter. This Ganpati has no idea.
No, do you have that judgment with you?
No, no,
Gokul.
no.
What happened to that case? In Gokul's case? Is there any discussion?
No, ma'am.
Any ground, anything is taken
Nothing,
here?
ma'am. Even the witnesses examined by the informant, they have not supported, man. They have shown, they have said ki we saw Gokul submitted before us. Ei bandhukare mutaku mari. Only Gokul.
Gokul.
4, 5, 6, 7 all.
Ganpati.
4, 5, 6, 7 all PWs. PW 1, 2, 3 are the informant, his wife and his daughter. His daughter has not said anything about any other else except Ganapati Maira. PWC 2 may be seen her deposition. PW2 is at page 44, 45. She is the daughter of informant. The dispute between Ganapati and that informant. Ganapati is
You are Jairam, huh?
Jaram Pai. Ganapati is the home guard.
The Ganapati was holding a gun.
Yes, he is the Gramaraki, and he was obstructing the illegal act of that this informant in this case, my lord. He is the sarpanch.
Ganapati Pai fired a shot, the result of which the shot struck on the wall.
And no arms act there, my lord. Only 307, 506. This PW1 has 3 has practice of hiring manner. He is a dealer of illegal contraband guns, man. Therefore, several cases has been registered against him.
But no gun was found, huh?
No gun was found and no arms act there, man.
Charge sheet is filed, is a false case. Charge sheet is narrated severity. Suit, kitne? There are many cases pending, huh?
Many cases, man. In the case of 42 murder, hearing a gun sound, when that informant came, this PW3 assaulted her and her husband. Therefore, case number 42 was lodged against him. In the supervision report, everything has been detailed.
See, the charge, if you see charge is completely
Wrong, man.
You fired a gun.
Yes. First charge
As a result of which the accused stuck on the wall.
Yes.
उसका कॉपी कर दीजिए गणपति चाचा
Charge.
सी रीड दी चार्ज
First charge itself is wrong.
गणपति नाटा चेंज कर दी गणपति what is the allegation is Ganapati filed the fire 307H and it stuck in the wall. Daughter and mother
Wife.
has seen it.
And doctor has just submitted.
This is the story, the prosecution story. What is the charge? What is the charge? And you summon in 319 and copy paste the charge and let him face.
The deposition of the PW2.
Forget about deposition. Charge is defective. It is completely prejudicial.
One more thing, let's show that appearance is absconded. That point
Don't say all this at this stage. When appeal is being heard, absconded. What?
My learned friend is claiming clarity at the another appeal case was settled.
Because he was absconding during trial, therefore his appeal has to be dismissed. That is your argument. Then
Split up. Therefore, the case
we are hearing appeal, sir. Appeal. Absconding, that story has gone. He is convicted. He was in the custody. Everything is gone. Absconding is neither here nor there.
conduct of that.
Absconding and all these things are only for the purpose of
And
bail.
was issued and very
Purpose
simply
of
was
bail. But
recalled, madam.
what kind of charge is framed here?
I was custody 2 years, 22 days. And conviction is of 4 years, madam.
See the witness, all the witnesses have said that it is Ganapati who has done it.
Ganapati saw the gun and said, "Okay, I have shoot." Even his daughter is not supporting, madam. PW2, his daughter is supporting, only saying about Ganapati,
Yes, everybody is saying Ganapati.
not saying about any other's presence. PW2.
Accused Ganapati fired,
Right.
aiming at my father.
ଆଉ କାହା କଥା ବି କହୁନି, ଆଉ ଅନ୍ୟମାନେ ଆସିଥିଲେ ବି କହୁନି. Because of enmity, PW1, PW3 supported.
Ganapati fired. All the witnesses are saying Ganapati fired. And Gokula and you were together. You have given company. Prafulla, Gokula, and you
Yes.
were there with the Ganapati. All of you went there. And Ganapati fired
Right.
because he was having a revolver, whatever, gun. He gave a fire. That fire didn't hit anyone. It hit in the wall. That was witnessed by the daughter and the
Wife.
wife.
Daughter
Both of
is-
them are narrating the same story.
Daughter is not supported, man. Daughter said only about Ganapati, saying nothing about anything.
Anyway, but this is the story, prosecution story. Investigation is completed.
Yes.
Charge sheet is filed saying that it is a false thing. And Ganapati faced the trial. Ganapati and Gokula faced the trial.
Gokul and that Prafulla.
And
Gokul
on the basis of evidence occurred in that case,
Yes.
you have been summoned,
Yes. 319%.
390. And you have been now convicted. Just see what happened to Gokul, because Gokul's case and your case is same. Gokul has filed an appeal already. Order लेके आओ. नहीं
केस से मिल
हाँ?
एसटी केस एक्चुअली गजपति ପାରଡ଼ା କମିଟି ଥିଲା
ଏତେ ସାର୍ କିଛି ମିଳୁନି। I have searched anything, everything. ଖାଲି ଗୋକୁଲଟା ପାଇଲି ଯେହେତୁ it is in the
नहीं गोकुल बाकी जजमेंट है गोकुल का.
ମୁଁ ଏଇଥିରେ ଖାଲି ଅରିଜିନାଲ 251 ଆଣିଲେ ମିଳିଯିବ।
Huh?
ଆମର
That's
ହାଇକୋର୍ଟ
what I told him to get it.
ଆ 2007 ଡିସ୍ପୋଜ ଅଫ୍ ହେଲାଣି, ସେ କୋଉଠି ଥିବ ବି ରେକର୍ଡ।
Section तो नहीं लिखी हुई.
one जो earlier dispose of ହେଇଛି ସେଟା digitalization ହେଇକି ଥିବ record.
Right on.
I'm relying on two decisions. Mere presence is not sufficient.
1 minute. What is the FIR? FIR number 8.
FIR number 43, madam.
40?
43. It is the counter case of 42. Laws against the informant of this case.
नहीं, this case FIR.
This case is 43, madam.
GR case number 205/88.
Yes.
Huh?
Yes. It is just page 27, madam. FIR is 27.
No. FIR number, where is FIR number?
Digital page 27 number is
Page 27, my lord.
First in 43.
43 in the bracket 3 of 88.
Pertaining to an incident happened on 6/9/1988. 59.
Incidents 59.
5989. 598.
At about 8 p.m.
About 8 a.m. An FIR being PS case number 43. Paralakundi PS case.
Yes.
43 of 1988 was registered. Investigation of this case was carried out by the local police, and a charge sheet and submitted on 25/1/88. 89 हो, नहीं 89 हो, 89 huh? 89 type it with me. नहीं 24 12/88 24/12/89. 24/12/89. The the investigation revealed that on 6/9/1988 at 3:30 a.m. a complainant Panchu Singh Maji of Ajaygarh filed a written report inter alia alleging that on 5/9/88 at about 8 p.m. one Gokul Chandra Bishoy came to his house through the backside bari along with the Praful Pai, Jairam Pai, bracket the appellant, Ganapati Pai, full stop. With an intention to kill him. At the time he was sitting in his courtyard. His daughter and wife were also taking meal. Ganapati Pai fired a shot, as a result of which the shot struck on the wall. This was seen by his daughter and mother, daughter and wife. After hearing the gunshot sound, Bamadev Pai, Nilamani Pai, Prabhakar Pai, Ochut Pai, Subhas Mocha, Pramod Rao, Buddhiram Lima, and Kaliva Lima came there. The investigating officer thoroughly investigated the allegation and came to the conclusion that due to there are multiple cases, civil cases, pending between the complainant and the accused persons, and the narrative of the complainant making allegation against the accused persons appears to be false. Therefore, a closure report was filed. Contrary to the closure report, the magistrate took cognizance. Contrary to the magistrate took cognizance of the offence against
Three.
three persons, namely
Gokul Bishoy, Praful Paik, and Ganapati Paik.
Gokul Bishoy, Praful Paik, and Ganapati Naik. They
My date may be
on
31st March 89.
31st March 89.
That was August, no?
They full stop. All the accused persons appears to have faced the trial. During the trial, it is alleged that certain evidences come on record against the present appellant. Therefore, by invoking the provisions of section 319 CRPC, the prosecutor move application. Accordingly, the present appellant has been summoned and faced the trial.
If required, date may be 10/11/89.
Face the trial. I have also perused the charge framed against the appellant. The charge order is 8/2/1990. It appears the trial court by completely trial court has simply copy paste the charge for charge order charge order with oblivious of the fact that there is no allegation against the present appellant regarding regarding firing of a gunshot by him. The said allegation is only against the co-accused Ganpati Pai. Be that as it may, the appellant faced the trial, and eventually he has been convicted by the impugn order dated 22/10/1998. 1990, sorry, 1990. The in lieu of his conviction under section 307/34 IPC, he has been sentenced to rigorous imprisonment for 6 months.
4 years, sir. 4 years.
For 5 years.
Yes, for 4 years. 4 years. And on the count of the conviction under section 506/34, he has been sentenced to 6 month RI. 6 month RI. Mr. SN Panda 4.
SN Mr.
Sorry, SN Mr. 4 at this stage submitted that the appellant's case is the allegation against the appellant is exactly same as against the co-accused Gokul Vishwai. He further submits that Gokul Vishwai appears to have been convicted and has filed an appeal bearing number
Criminal appeal number 251 of 90.
251 of
1990.
1990.
Number.
He further submits that the appeal was disposed of by Lokadara,
By this honorable court.
by this honorable court, by
25/7/2007.
since there is a direct bearing for the outcome of the case in Gokul Bishoy, in the present case, it would be appropriate that the record of that case is summoned from the summoned. Accordingly, the registry is directed to ensure summoning of the record of the case, bill number so and so, and released the matter on Tuesday. Now, equitable कराएंगे इसको. I'll just stop. अब dictation देंगे. अब कोई तो है नहीं. Anybody is there? Yes, sir. You ready? Anybody is ready? You. Nobody is ready. If anybody comes, then tell me. So, I will dictation do.
My lord has engaged me in the 4 cases, man. This is the last case.
ଆଉ ନେବା ପାଇଁ କହୁଛନ୍ତି ନା କହୁନାହାନ୍ତି ସେମିତି ଡାଇରେକ୍ଟଲି ଆଉ
We will not let you go like this.
Yes.
ଏଇଟା
Mishra sir, वो जो तो खाली अच्छी. छोटो मोटो just if he is there, just see file is there, give him. Just see small matter
Yes,
if is
I
there,
can.
we can finish it up.
Yes.
Small matter, 6 months and all. Just check files are there, just check it up. Just go through.
Yes.
See, if you don't do like this, these matters will be never over.
I am always ready to do.
Your son or daughter will come and argue the matter. So better that you should finish it up. Okay. 13.
1-3.
What is the offense?
Only 498 for DP Act matter.
Sentence?
2 months. And sorry,
2 years.
2 years.
2 years.
And already undergone 6 months. Maybe taken up 2 years matter.
Big case, sir.
13, no, 1 minute.
1 and 2 died, only 3 and 4 matter.
1 minute. 1 and 2 died, huh?
And these two brothers are 57, 55.
1 and 2. 3 and 4 remain, huh?
Yes.
3
is the husband.
Is the husband. 4,
4 is the brother-in-law.
brother-in-law. Only conviction under 498.
498 for DP Act.
1 minute. 1 minute. Which year? 94. 94.
Now 57, 55. As I said.
Undergone period?
6 months, madam.
6 months already undergone.
Custody on 30th March 93. Bail bond was given on 13/9/93. Almost 6 years. 6 months.
6 months.
13 days.
Sentence is
2 years.
2 years. Sentence. Sentence is 2 years. I know it's 524.
Your Lordship, may I say one thing? Applicant number 3 टाइप जो तार फाइन टाइप एनहांस भी कर दिया तो 4 टा बेडरूम अच्छे पीरियड ऑन कर देले भी चल 3 and 4
हस्बैंड को हस्बैंड
कर दो अब 4 तार बेडरूम अच्छी तो ताकू
बेडिडेन अछि
आज्ञा रिपोर्ट रिपोर्ट ता देछि रिपोर्ट भी अछि आज्ञा रिपोर्ट
बेडिडेन
आज्ञा देखो 3 कहता ना 74
बेडिडेन
वो ना सफरिंग फ्रॉम chronic disease बोली बेडरूम अछि
what do you say?
Yeah.
See, 4 is bedridden.
Yes.
Sending him to custody. 6 months undergone.
Yes.
Period undergone, so far as he is concerned,
Yes.
will do it. Insofar as the appellant number 3 is concerned, his husband, 6 months undergone. Period. I'll increase the fine.
Yes, sir. Right.
Increase the fine amount. That is better way.
Minimum amount may be imposed. कारण laborer आज्ञा तृतीय श्रेणी बंद पाठ पढ़छन.
How much you expect?
ସେତେବେଳେ 500 ଟଙ୍କା କରିଥିଲେ କିଛି ଗୋଟେ.
How much? How much I expect?
तो सर कर दो
Huh?
10,000 कर दो
10,000 देही परले तो
ଦେଇପାରିବେ.
कर दो तो किसी असुविधा नहीं.
आज्ञा
No, what I'll do is I'll make 5,000 and default sentence 3 months.
Yes, sir.
Default sentence 3 months.
Yes, sir.
He will not pay and
Yes,
it has to
yes,
be
sir.
paid within 1 month. Otherwise, he will be taken into custody.
Yes, sir. Right.
What do you say?
3 months film.
How do you guess? 2 months degi. If he doesn't pay, then 3 months sentence.
Yes, yes.
Right.
उनको करीब कर दो. दीजिए. लिखिए सर. He is bedridden, na? The report is there already. Take out the report, copy of report. Last page of the report. Huh? A report is there.
Report.
Chronic disease, suffering from chronic disease. High grade dysplasia. Person लिखी दियो. So दे दियो फाइल में dictation will come. Huh? We can choose. Okay, ना तुमको registration दो चेष्टा करो कुछ और कोई नहीं देखो report is there. I'll do it. I'll do it. Huh? I'll do it. अभी कर दीजिए. अभी दीजिए. Okay.
My name is
appearance लगी दो.
ଗୋଟେ ମ୍ୟାଟର ଗୋଟେ ଅର୍ଡର ରିଜର୍ଭ ଅଛି ସିଆର ନମ୍ବର 252 ଅଫ 1990 ର ଗୋଟିଏ କେସ୍ ଯୋଉଟା ଥିଲା 395 ଯୋଉ କେସ୍ ଟା ସର ହେଇଥିଲା ତାର ନୋଟ ଅଫ ସବମିଶନ ଟା ଆଇ ଏମ୍ ସବମିଟିଂ ରାଇଟ୍ ନାଉ ତାର ସେଥିରେ ଆପିଲ ନମ୍ବର 2 ଇଜ आल्सो डाइड ତାର ମେଡିକାଲ ସାର୍ଟିଫିକେଟ ତାର ଡେଥ୍ ସାର୍ଟିଫିକେଟ ଟା ବି ଦେଇ ଦଉଛି
दे Saturday.
ଏଇଟା
I think last Friday, last Tuesday I did.
Last team.
ଲାଷ୍ଟ ଟୁ
Tuesday, na? So they, I think more table roche dictation दी. हाँ सीटा written.
ନୋଟ ଅଫ ସବମିଶନ
Seda, on sentence of hearing notes that I have submitted and they are
अब दे दियो लगा दियो more table roche. ठीक है. Okay madam.
with death certificate.
ଡେଥ୍ ସାର୍ଟିଫିକେଟ ତଳେ ଅଛି
How many appellants were there?
6.
6 out of 6 2 and 3 died ଅଛି out of 6 appeal number 2 and 3 died 3 ର died ଥିଲା already ତାର record ରେ ଅଛି but 2 ଟା ମିଳି ପାରୁ ନଥିଲା ଯୋଉଟା କି ମୁଁ ନେଇ ଆସିଥିଲି
ठीक. Yes.
Item 9.
दो.
Case para item 9. Charge matter frame under section 302 34 IPC matter. Against these two appellants matter. Appellant number 1 is the son, number 2 is the father matter. At the time of judgment, appellant number 1 is about 25 years and appellant 2 55 years matter.
Yes.
But after conclusion of trial matter, the London trial court held that the appellant number 1 held guilty under section 304. Not one of part 1, part 2 had not mentioned 304 and sentenced to undergo imprisonment for 10 years. So far other petition appellant 2 is concerned, only he is convicted on section 342 of
Okay.
wrongful arrested.
30 sentence.
6 months, man. 6 months. Oh, one.
One means
Son.
304.
304.
Okay.
And so far 304 is concerned matter. There are admittedly, as per the prosecution, there are 4 eyewitnesses to the occurrence. Pitbull 12 is the son of the deceased, who is the matter the informant, and Pitbull 4 is the daughter of the deceased, and another 2 matter. They stated that the neighbor, and they stated that they are the eyewitness to the occurrence. But in fact, matter. Two, 3, 4, and 12. 2, 3, 4, and 12 are the eyewitness to the occurrence.
PW2,
12,
12,
12, 2, 3, and 4.
3, 4, and 12. Huh?
Correct.
They are the eyewitness.
Bad. 12 is the son of informant matter in this case. 4 is the daughter of the
Daughter.
matter.
Daughter of?
Deceased.
Daughter of
12 is son of the deceased and 4 daughter of the deceased.
this.
2, 3 are matter they are the nearby persons. Matter.
And who? 4?
4 daughter, 2, 3 nearby persons.
No. Son. 2 is son of the deceased.
None. 2 no. 12.
12 is son of the deceased.
Son of the deceased and the informant.
Yeah, they are independent witnesses.
Independent. 2, 3 are independent.
2, 3 independent. Huh?
And Pitbull 1, 5, 7, 9, 11, 16 are the post occurrence witnesses.
To PW?
Pitbull 1, 5,
These 4 are eyewitness. Huh?
4 are eyewitnesses.
Eyewitness and
1, 5, 7, 9, 11, 16 are the post
1,
occurrence witnesses.
5, 7,
9, 11, 16.
11 and 16 are post occurrence.
Madam. Pitbull 10 is the doctor, madam, who conducted postmortem examination.
Then PW10 is doctor.
Pitbull 15 the investigation officer, IU. Others are madam, she's witness, others are there. But interesting in this case, madam, the defense madam examined 9 witnesses as GWs. So substantiate their defense madam.
9 witnesses.
9 witnesses.
9 witnesses. EW. Yes.
Alleged occurrence have been taken place, my lord, on 20th 1 1992. On that day, particular day, my lord, 20th 1 1992 at about 7 a.m. On the particular date, the wife of the appellant, my lord, while standing, he saw this deceased my lord drove the bullock to the land of the appellants, and there are there my lord exchange of hot words between them. It is alleged that thereafter hearing shout, the father of the appellant was appellant to came there and caught hold of the deceased, and by the time the appellant one came from his house holding a lathi, and the appellant this appellant stated to the appellant to leave him, I will kill him. Thereafter, when he left the deceased, he ran away. By the time they alleged that this appellant attempted blow by means of lathi on the left side head of the deceased, single blow. Thereafter, when the deceased fell down, the informant tried to lift him. By the time this petitioner also assaulted the shoulder of the that informant. That is the whole case, man. With regards to for better appreciation, I want to place the evidence of PDL 12 first and then PDL 4.
PDL 12. Who is the injured witness?
PDL 12.
He is also injured.
Injured, but that has not been even no separate sickness.
But that is what he said, that I was also beaten up.
Beaten up.
Yes. Yes.
But at page 115. I know both the accused persons in the dock. The deceased Girish Chandra Makeup was my father. The occurrence of this case took place on 20th 1 92 on the Monday at about 7 a.m. At 7 a.m. myself and my sister Puspa Pidul were on our passing floor towards eastern side. At that time, my father was returning after a bath, and while he was drying cloth, the wife of the accused Vinod, Renuka, was found driving the bullock from our barry to our barry. The bullocks damaged the banana tree of our barry. My father asked me to drive away that bullock from our barry. When I did not listen to him, he got annoyed with me and himself proceeded towards the bullock to drive it out from our barry. When my father chased that bullock, it again went inside the barry of the accused. Then Renuka, the wife of the Vinod, raised Hala. Hearing Hala, her father-in-law, accused Gunadhara, came and picked up quarrel with my father. In course of quarrel, Gunadhara came inside our barry and caught hold of my father near the
any matter?
tree of
1 minute. Yes.
I'm told that I'm told that my lady is not feeling well. So
No,
case will be taken.
no, that is a partly true. The other part is lot of judgments are there. I am giving practice. Otherwise, what happens is it piles up. Then that is the reason. I'll hear his matter, then I'll start.
Tuesday.
Yes. Yes.
reading 116.
Yes.
Near the
Gununidhi
banana-
came inside our barry and cut hold of my father near the banana tree.
Second time. And asked his son, accused Vinod, the present appellant, saying Vinod,
Dodia.
sir,
Khatam kariye.
and this accused Vinod came running to the spot, being armed with a bamboo lathi, and asked his father, saying, Papa, chhado, taku mu khatam kari debi. Seeing accused Vinod came running to my father, being armed with a lathi, and requesting his father to leave the deceased so that he could kill him, I started running towards the spot to rescue my father. At that moment, I saw accused Vinod giving a lathi blow to the left side head of my father, causing severe bleeding injury. Then accused Gunadhara left my father, and my father fell down on the ground.
Hurriedly, I rushed to
Hurriedly,
the
I rushed to the spot and I tried to lift my father from the ground. At that time, accused Vinod dealt two lathi blows my shoulder, and result I sustained a swelling injury. Bhaskar Mekab, son of Damodar Mekab, another Bhaskar Mekab, son of Khalid Mekab, Panchanam Das, and my sister Puspa arrived at the spot at that moment. After the arrival of those persons, I want to take a pause, my lord, because my lord, though he specifically stated in the FIR as also the evidence in chief that at that time, my sister Puspa is PW number 4, PW 4, arrived. Another Bhaskar makeup. He also examined at period 2. Bhaskar makeup. Both are Bhaskar. 2 and 3 are Bhaskar makeup, but the father's name is different manner. They are examined at 2 and 3. But in fact, manner, one independent witness, namely Panchanam Das, have not been examined. That is my point, manner.
Is it necessary?
No, it is not necessary. There are distance, but in fact, manner, why an independent witness with him, manner?
But three independent witness name is taken. They have chosen
But
to.
he has though FIR named and the eyewitness stated his name, but he had not been examined. For better evidence.
That is
Man.
it is the prosecution's outlook.
Section
Man, that
174.
is the law. In fact, I may point out that.
Yeah. That's one of the point you have.
Panchanam Das has not been examined.
Because you couldn't find any other point.
Man. After arrival of those persons, the accused person fled away. Then I, along with the above named person, shifted my father from the spot to the near our house. We made my deceased father lie on the Daudia cutter on our passing floor at our house. My father was found not in sense at that time. Then Charut Chandra Pradhan, Basant Mekab, Bhima Mekab, Bipin Bag, many others came near our house. Due to bleeding, the earth near the spot was soaked with blood. We put the lungi on the wound of my father to control the bleeding. Then I made arrangement to take my father to Vasta Hospital for treatment. My father was taken to hospital in Daudia Kata, carried by Bhima and a Puspapati, and followed by them in the cycle. We know Bihari Samanta, the village GR also came to Gramaraki, came to our house. He took me to the Basta in his cycle. After the shifting of my father to the hospital for treatment, on the way we met Ashok, who informed us that my father expired near Gandhi Chowk of Basta. So I did not go to hospital and went to PS to lodge FIR. I arrived at PS at 9:30 a.m. and orally reported the matter to the OIC. The voice of the PS reduced my report into writing, read over and explained its contents to me, and after satisfying myself the content of the FIR so prepared by the OIC, I put my signature thereon. This is the FIR prepared by OIC in my presence at the marked exhibit 8, exhibit 1, exhibit 8 by 1 is my signature thereon. Gramaraki Vinod Bihari Samanta also accompanied me to the PS. He signed in the FIR. After the FIR was lost, the OIC examined in connection with the case, examined me in connection with this case and took.
So nothing could be
This is the
elucidated from this witness.
And likewise, my lord.
Cross examination also, I don't think
No.
that is so good.
And PDO 4 or PDO 3 and 4, they have stated so, my lord. Like that, my lord.
Same.
Same thing, my lord. But in fact, what happened in this case, my lord, the very important thing is DW 3 and DW 9. I am permitted to read out, my lord. But the deceased was working as a teacher in a UP school. In order to get benefit, financial benefit, the wife of the deceased written a letter to the BDO and other the officials, stating there in that letter that my husband died due to accident. That is the case, madam.
Akasmik mrityu.
Accident.
Sudden death.
And it is a case of murder, madam. But they have stated that died due to accident. But they don't see.
Akasmik mrityu.
To get the financial benefit.
To take insurance money.
My lord,
To take insurance money.
Service
Rehabilitation
scheme available.
scheme.
it's not other, my lord, the benefits, my lord, financial benefits.
The defense has examined 9 witnesses. 3 of them say that the plea of alibi is needed.
But,
Second,
150.
Wife of the deceased.
My lord,
Wife of the deceased attorney.
my lord.
She has not been examined.
She has not been examined in this case.
that
Otherwise, you could have,
Cross-examined.
Yes.
cross-examined,
confront kari hi tha. She's not a
confrontation.
part.
Widows 3, my lord. I have been working as assistant teacher of Agi Tanduari People School since the year 1989. Girish Chandra Mehta, the deceased, was the headmaster of the Bhogi Chakur Rai UP School up to 20th-1/92. On 20th-1/92, I submitted this application marked Exhibit X to the video Posta block through SI of school Posta Circle. I have written this application in my own hand and this is my signature therein. It is marked as Exhibit 1. Exhibit 1 by 1 my signature therein. Through Exhibit 1, I intimated to the video Posta block about the makeup. Bhagi Chakurai UP School comes under SI of Posta South Circle. On 20th-1/92, Nirmala Das was in charge of SI of school. As SI of school, Bimal Das was absent from the headquarters. I was taken to video Bosta along with the application. Exhibit 1 is my Exhibit 1 by the said Nirmala Das.
No, this is fine person.
That is exhibit
A.
Paragraph
A.
3 would be relevant. Your Worship.
I submitted Exhibit A before the video Bosta block. The video Bosta I received Exhibit A from me. I submitted Exhibit A before the video Bosta block in my official capacity. This is Girish Chandra Mehta used to attend the school from his village every day. Girish Chandra Mehta is the Giribala Mehta is the wife of the Girish Chandra Mehta.
Para
Let us
3
see
would
the
be
exhibit. Where is that
Your
exhibit?
Worship, para 3 would be relevant. Para 3, I'll just
Para 3 of
3 of that particular witness.
On 20th-1/92, Ashok Mehta, the nephew of the deceased, informed me about death of the deceased. On my asking as to how the deceased died, Ashok told that the deceased died due to assault of 2 of his neighbors. I prepared the death report Exhibit A from the intimation of the block. When I submitted the death report, Exhibit A prepared by me before the video, Posta block, he instructed me to scribe that I died a sudden death.
So he instructed me. The
Always.
video instructed
The
me.
legal heirs of the deceased would not be entitled to avail the CIS amount. Again say, I did not submit the death report which I prepared in school and instead of
But what will you? What is the?
not
They
helpful
might
to
have
the-
cheated.
Madam.
But that is a different consequence also.
but
And the witness says that they have
due to assault.
they told lie
Madam.
only to get that benefit.
benefit man.
Worship,
But
Let it be.
even if a case of
in
murder
fact,
manner,
BDO instructed to write that it is accident.
Whatever they have cheated the video, whatever. That is a different consequence also.
Because the
Madam.
nephew of the deceased say that there is an assault between the neighborhood.
It is not that they didn't know that a murder has taken place and they have given this.
Yes.
Pidol 5 is the video manner.
Hmm.
I was the video, Bosta in month
PW?
5.
DW.
5
Huh.
at page 155. I was a video Bosta in the month of January 92. I was transferred from there in the month of August 1992. On 21st-1/92, I received the Exhibit 1 from the Ravindra Naran Mehra, assistant teacher of the Bhagi Chakwai UP school. I was intimated in this letter that the deceased Girish Chandra Mehta, headmaster of school, died on 21/92 at 8:30 am. Received the letter which is signature and date. Exhibit 1/2 is my signature. With the date thereon, I made over the letter Exhibit A to SI of school. Basta Circle to deal with the matter. On the same day, that is 21/1/92, I received an application of Giriwala Makeup, wife of Girish Chandra Makeup. This is that application of Giriwala Makeup marked Exhibit B with objection. I received that application with the initial with that date B/1 is my initial with that thereon I endorsed that application to SI of school to deal with the matter. In that application 82, I also intimated that
Yes, I accept it.
Madam,
But what is the consequence? Can on the basis of this, can you doubt to the evidence of all the eyewitnesses?
eyewitnesses, my lord.
And the doctor.
How will you discard the evidence of PW 2, 3, 4, and 12?
PDOL
That's the
2
question.
and 3, my lord. PDOL 2, my lord, PDOL 2, 3, they are the chance witnesses, my lord. My argument, my lord, they are chance witnesses. They have stated that their house situated 50 to 40 to 50 cubits away from the accused persons, my lord. And
50 cubits.
cubits away from
The
the
chance witness, how does
chance, my lord, that even if they stated that they had seen the occurrence, but in fact they had not seen the occurrence as because they are chance witness since they are interested for the successful prosecution case.
Suggestion रे भी सीटा नहीं है.
And PDOL 4, 12, 2, 3, my lord, though they have stated that they had seen the occurrence, my lord, in fact, the accused person taken P of alibi. One thing, P of alibi, my lord, at the relevant time, the other DWs they stated, the wife, DW9, they have stated that at the relevant time, her other-in-law and the accused went to cultivate the land. They are not present at this spot. That part, my lord, dismissed by the trial court. And second thing, my lord, here is the case, my lord. One lathi was recovered from the house of the accused appellant. In that lathi, my lord, human blood patches are there, but that has sent to chemical examination report, and that is page 181.
what was the report?
Page 181, my lord.
Exhibit, which exhibit?
My lord,
Report, which exhibit?
181. Extract of lathi to simulate blood, human blood A, group A. But the group of the blood group of the accused, neither the accused nor the disease taken by the investigation agency.
Which exhibit is that?
My lord, page 181.
Exhibit 15.
Exhibit 15. 1-5.
State Forensic Science Laboratory result, Rasugad. Report of biological and serological examination. Exhibit 1. Madam, the-
Somewhat flat.
Human blood, it was found group A.
Group A.
Huh.
But in fact, madam, the blood group of the accused has not been taken by the investigation officer. So also the blood group of the deceased has not been taken, my lord. So, my lord, human blood though found, my lord, but in fact another thing, my lord, the Latin question that has recovered from the house of the petitioner, appellant. PW 8 is the witness to the seizure. He has not supported at all the about this seizure, my lord. So the factum of seizure has not been proved, my lord. Here, yes, my lord. PW 8, my lord. I'm going to PW 8. He has not supported the. So the factum of seizure of the lathi, my lord, that has not been proved by the prosecution agency. That is it.
Correlation.
Police did not seize anything in my presence.
My lord.
In connection with the case, on the visit to crossing.
And other MOs, my lord, that is MO 2, 3, and 4, my lord, gauze, bloodstain gauze, and Lugi and Banyan, my lord, that has been not kept in a safe custody or not sealed, my lord, at all, my lord. For that, there is benefit, my lord, so with regards to chemical examination report. One thing. And so also, my lord, though there is, my lord, will not dissimulate the case of prosecution, I would once say for better understanding, I will read out the section 304, madam. Punishment for culpable homicide, not amounting murder. Whoever commits culpable homicide, not amounting to murder, shall be punishable with imprisonment for life or imprisonment either prescription term which may extend to 10 years, shall also liable to fine if such act which death is cause is done with intention to causing death or causing such bodily injury as likely to cause death. Man, here the first part, man, intention is there. The prosecution has to prove the intention.
Intention there, witnesses are saying, you come and I will kill.
Come to
No,
the second part, madam.
That is
Second
it.
part,
Yes,
madam.
there was a
Madam,
enmity.
Part 2, madam. I'm coming to part. Would the implement either decision for term which may extend 10 years. Here, madam, he has imposed 10 years.
Sentence is
10 years or with fine or with both if the act is done, very important, if the act is done with the knowledge that it is likely to cause death, but without any intention to cause death or to cause such
See,
bodily
the
injury.
first part is with intention.
But
Second
the-
part is knowledge without
Knowledge.
intention but knowledge.
Knowledge. That's true, madam. But in fact, madam, the court below, while convicting, madam, commit under 304, neither part 1 nor part 2.
According to you, it should be part
It is coming on
part 1.
Part 2 as may extend 10 years. And he has undergone
Part 2, it should come fall under part 2.
Part 2. Part 2 hele,
Knowledge without intention.
madam, it will extend to 10 years. Madam. Extend 10 years. He has given the highest punishment 10 years. Madam.
That's the
And he is in custody. Has been detaining the
custody for
4 months.
4 months only. 10 years sentence.
May I? Yes. The
4 months, 14 days.
difference between 302 and 304 part 1 or part 2, the only difference is intention and the knowledge.
Knowledge.
Your Lordship. I'll place the PW 10, who is the doctor.
Part 2 is having knowledge,
Knowledge.
without intention.
Intention that the
And
first
part 1 is
intention.
intention.
And it is a case of due to sudden provocation that the occurs second.
I'll place that there is no sudden provocation and the previous enmity is also admitted by the present accused person. I'll place question number 47 of the 313 statement. Your Lordship.
Which number?
47.
Yes. 80 PS from the evidence.
Yes.
A PW 2, 3, 4 and 12.
313 statement, Your Lordship.
Wearing a napkin. 47 to 313 only I am reading. Okay, 47. Yes. More. What is written? More.
ମୋର ମୁତାପାର କଦଳୀ ଗଛ ଆମ
ମୁତପାର କଦଳୀ
ଜମି ଆମ
ଜମି ଆମ
ବାଡ଼ିକୁ
ଉପରକୁ ଲାଗିଛି
ଆମ
ସେଥିପାଇଁ
ଆମର ତାଙ୍କ ସହିତ ବିବାଦ ଲାଗିଅଛି.
ଅଛି
The previous enmity is admitted. Your Lordship.
that is there. The conduct, they see the
No, Your Lordship,
lady member was
no, Your Lordship, I'll just try to show that the intention was there. And also I'll place PW 1.
you want that it should be part 1.
No, I'm saying it is 302 only.
Division
Where is your appeal?
It will go to neither enhancement final.
In his appeal, you want to
Process final, enhancement final.
where is your
That's
appeal?
why, since there are eyewitnesses to the
You may be right.
the
It could be
conviction.
302 also.
Yes.
What one decision, madam, single rule. Night rule. In the chapter, para padhe school. Para 22.
See, if the blow is repeated,
Then
the
madam,
intention comes.
exactly that
If the
is
blow is not repeated, there is no intention.
that is the view.
But you have knowledge that I am giving a blow in the head, then
Might
he
not.
may die. So the knowledge part is there. Intention may not be there
Mental-
because you have not repeated the blow. So therefore, it is part 2, not part 1. Part 1 is only intention. You have intention to kill, but somehow
Here it is
single blow.
total absent madam due to his father call him and he came with a lathi and
But you had knowledge.
madam. But
You had knowledge because see you are giving blow in the head,
but the each and
likely
every,
to cause death.
paragraph 23. Here it is case madam, one single knife blow on the belly.
That is on belly. It is on.
No, I would guess the
Doesn't-
single.
Huge, but that's
So
the
far,
difference.
Person by the concern that
From record, he was a young man of.
he had about 28, 25 years.
Hmm.
Age at the time of incident, studying in class 12, there was a history of
Matrimonial
dispute between the party, sister and the brother-in-law. Why it is
It is natural young man, emotionally upset.
emotionally upset. See his sister allegedly treated by, but here the wife allegedly treated by the
Hmm.
by in-laws, where the deceased and Abbas Sabi came to their residence, leading to the raccoons. It is difficult to visualize that state of mind of the person as well as the father Asghar Ali. The tension was building up since morning as Abbas had accepting that his wife Azhar should come to his house and then insisting on the cupboards key of the Ahmedabad house at the handover the him. In the important note that incident.
Here also the tension was built up.
Madam,
When the father came, father asked, go and do it.
exactly.
He said that I'll not
Exactly,
do.
exactly.
Then the
Yes,
tension
Dr. Pal.
flew up.
And page paragraph 24. We are in agreement with the view taken by the High Court that the entire incident had occurred in a heat of moment and neither party could control ultimately asserted into the.
You are right.
That being the position, since the High Court had brought down the charges from the report part 1 IPC to part 2 IPC, we feel that it would be the interest of justice if the sentence applied question of aggressive Lokhandwala
Further modified to the
further
period.
modified period of undergone. Implement on much waters have flown down the river by this time. The unfortunate incident leading to loss the precious life and a sustaining injuries by couple others had happened
Spur
in
of-
the spur of a moment. Important matter.
When
For
concurring-
here, but therefore, while concurring with the input
Alteration.
judgment, the High Court at 6 by 2016, if so far alteration of the conviction is concerned, we are of the view that sentence imposed upon the appellant should be altered to the period of incarceration already undergone by him. That being the position, it is not necessary to pivot into the elaborate upon.
But what is the period already?
And here, madam, perhaps they have imposed, High Court imposed 5 years. 10, not 10 years.
But what is the period undergone?
5 years, madam.
No, 5 years is the period, the sentence. What was
Sentence.
the period? 5 years undergone. So
That-
what was the sentence in this case?
In this case, 10 years madam converted and 5 years by the time 5 years are under.
Under 5 years, 50%.
Here it's a 4
4
months.
That is paragraph 10, that is mentioned paragraph 10. madam. Nikhil on counsel appellant on the outset submitted that trial was not justified in convicting the appellant on such 341 part 1 IPC. Though the High Court had altered the conviction from 1 under section 304 part IPC to under section 304 sorry 2 IPC, it was not justified in the sentence in the appellant to suffer RI for 5 years. Accordingly, the learned counsel is a clear case of acquittal. What's the point?
No, High Court has reduced to 5 years.
Madam.
But how much undergone?
Sir, go there.
That is not a
Nikhil Goyal, also the appellant, the trial court was not justified in convicting the appellant. Although the High Court altered the conviction.
Just I'm coming to court, my lord, got this system.
One of the three reports and was not justified in conviction. Trial court. Trial court just see. For conviction under section 323, the accused was sentenced to undergo RI for 7 days. And RI 304 part 2, the accused were sentenced to undergo 5 years, and fine of 50,000. Okay. 50,000 each. What is the period undergone?
5 years, actually.
5 years was sentence. Where from I'll get that undergone period?
18 months, which means-
Mhm. Did-
Document is,
Period that-
modified to the period.
Modify and reduce by-
हाँ, तो सही है।
କୋର୍ଟକୁ ଆସିଲା ବେଳକୁ ଜଷ୍ଟ ଲାଇବ୍ରେରୀରୁ ଜଷ୍ଟ ଆଣିଲି
Fine.
ଡିଟେଲ ପଢି
Already undergone by him. That
ସିଙ୍ଗଲ ବ୍ଲୋ ଦେଖୁଥିଲି
was
ଦେଖିବା ମିଳିଗଲା
modified to 5 years.
এটা-
It was modified to the
And you see,
Period-
para 22,
Huh?
para 22.
Para 22.
when the sentence was modified to the period of income already undergone by him.
It might
That
be
was
five, it might be. Right.
तो दिल
Para 22, while the sentence of Ashraf Ali was modified to the period of incarceration already undergone by him, comma, that
Stop.
Hussein Bhai was modified to 5 years. Maybe 5 years, maybe.
So what is the period undergone? Already complete sentence.
नहीं इसी से 5 years को जो modify करते हैं मतलब से 5 years का period होना
Hey,
ना,
trial
ना,
trial court also trial court also
Right करो.
ଯେତେ ଦିନ ରହିଛନ୍ତି ସେଟା ଅର୍ଡର କଲେ କିଛି ମେନସନ କରିନାହାନ୍ତି
କେତେ ରହିଛନ୍ତି?
5 ବର୍ଷ ହେଇଛି କିନ୍ତୁ ସେ କହିଛନ୍ତି
5 year sentence was imposed. No problem.
ବଟ୍
But the Supreme Court has converted to already undergone. What is the period already undergone?
ସେଟା ଲେଖା ଏକ୍ସାକ୍ଟ ନାହିଁ ସେଟା ଦେଖିଥିଲି
Find out.
ନାହିଁ
From the judgment, there must be something. That is important for us.
But another thing, my lord, your lordship may, my lord, impose if hold that this is a case under section 304 part 2, then it is up to my lord 10 years, my lord. Your lordship can impose any sentence, my lord.
That's right. But I just want to take clue from this. Just check it up.
Yes.
Somewhere it might have been written.
Punishment.
Paragraph 5 there, clause B. For the permission on section 2 part 2 IPC, original accused number 1 is imposed punishment sentence period already undergone by him. However, the amount of fine deposit
अरे
imposed
10 year पतला lower court, 5 year पतला high court. एमने period नहीं लगाने पड़े. तीनटा हो तो
so far original accused number 2 is concerned, he is sentenced to undergo arrest 5 years without disturbing the order granting fine and default sentence imposed by the court below for punishment of section 4 part 1 IPC. Original accused number 2 is on bail. His bail bond stands cancelled. He is directed to surrender the custody before 29 July 2016, along with his proper.
What is the period of incarceration? Nothing is there.
Nothing there.
What's the state of the
Period undergone is not there.
Actual कितने ऐसे
हाँ?
दिखाए 5 years से ही import कर सकती
5 years.
but period
I,
under-
okay, I'll ask. Who was the period? Who was the lawyer? Meenakshi Arora. Okay. And
Nikhil Goyal
Nikhil Goyal and Meenakshi Arora. I'll ask. I'll verify. I'll ask.
and Archana Pathak that big both are
Additional.
Miss Archana Pathak that big
She become additional solicitor. I'll ask.
just I have entered the course of got decision this is for one part 2 my lord
But it is a part 2. It's a case of part 2.
single blow here my lord is also single live blow
Single knife blow and time.
due to sudden purpose
Time is there.
wait a moment
See, but she had shown a judgment yesterday
my lord
saying that lapse of time cannot be a consideration for reduction of sentence.
but in a particular case there are other decisions are
That can't be a law in fact, because the consistent view of all the courts are sentencing has to be seen, the date of incident, the time lapse in between. Sentencing is the main consideration of that. But that judgment is going in a different tangent. Okay. I think do it. Sentence modified.
I also am suffering with a throat infection due to season
The season is like that. What?
and we are attending many functions marriage functions
Okay. Thank you.
obliged